All right, it's a couple of minutes after 1. I will call the meeting of the House Judiciary Committee to order. And I'm first going to ask Representative Greason if he'd lead us in the Pledge of Allegiance.
Be honored, sir. Thank you. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
So what I wanted to note, just for everybody's information, first of all, I did pass around, and I apologize for not doing this earlier. I did pass around the copies of the listing of everyone's email and phone numbers, so that everyone should have that. The other thing I wanted to let everyone know is that there will be a notice going out, in fact, of a revised executive sessions for next week. We're going to have executive sessions Wednesday and Thursday of next week, but on Wednesday we will start at 11 o'clock, not at 9 o'clock, and then on Thursday we will start at 9. For the Republican members of the committee, my plan is to have a caucus at 9 o'clock on Wednesday here in this room, so we can talk about what we're gonna do once we start at 11. So what I would like to do, if I could just take a minute, because I know that a number of people are new on the committee, and candidly, I'm new as chair of the committee, and so I just want to kind of go over things. I think I've got this correct, but if I don't, I will ask Representative Smith or Representative Wallace to correct me. So I should say at the beginning that Representative Smith and I have spoken this morning to basically try to see where both sides, so to speak, are, and I think you will be happy to see that we are in agreement on a great many of what we're going to discuss. But just to kind of go through this, where it appears to me that there is disagreement, I will call on a Republican for the motion favoring my view on the bill. I believe that's my priority as the chair. We will have a full debate on the bill. Don't get me wrong. Everybody will have a full opportunity to have a debate on the bill. If there is a motion, if there is a motion on a bill ought to pass and there's amendments, we will deal with the amendments first and then get to the main bill. It's my understanding, and again, I ask my colleagues to correct me if I'm wrong, that unless there's an objection, amendments can be voted on by either a show of hands or a voice vote. But once we then get to the main motion, either the amendment passes or it fails, but then we get to the main bill, that has to be a roll call vote in all cases. As I said, my plan is to allow a full debate on all the bills, whether if we have agreement or not. But I will not allow a filibuster, so that once everybody has had an opportunity to fully speak and have their say, I will then call for a vote. If the first motion succeeds, then that's sort of the end of the matter, and that will be the recommendation of the committee. If the motion fails, there can then be another motion. For example, if there's a motion of ITL and that fails, there can then be a motion of ought to pass or some other motion. If, for example, both a motion to ITL fails and then a motion of ought to pass fails, then the bill will go to the floor without recommendation, and both sides may file a report explaining their position. Is that,
There are other motion
Oh,
possibilities.
yes,
For
yes.
example, retain.
Right. Yes, absolutely. There can be other motions such as retain or whatever. Yes, for sure. The consent calendar requires, as I understand it, either unanimous or near unanimous agreement on a bill for it to be put on the consent calendar, and it cannot have a fiscal impact unless it's a bill with a fiscal impact that we are voting ITL. because then there isn't any fiscal impact. Reports, the history and the practice of the House has been that if you are the one that moves a motion, and then you write the report on the motion. If you're the one that seconds it, then if there's a debate on the floor, you will do the parliamentary inquiry concerning it. But that doesn't, that's just the practice. And obviously, if on my side of the aisle, so to speak, people want to have a discussion about that or want to have somebody else do it, we can have a discussion about that. And the same would be true with Representative Smith on the other side of the aisle. To just take a couple of seconds so people don't get sort of overly concerned about reports, especially if you haven't done it before. These reports are not term papers. It's 2 or 3 sentences basically explaining what the bill would propose to do, and why you either, if your side supports it or doesn't support it, why you support the recommendation that has been made, or if you're in the minority, why you support another recommendation. And then there has to be in the report, it has to say what the vote was of the committee when the bill came to the floor. And the other thing I would say is, if you're assigned to write a report and you have questions and you're on the majority party, don't hesitate to contact me and talk to me about it. And if you're in the other party, you should call Representative Smith and speak to her about it. We will both be reviewing the reports that are filed, and then they eventually go to the speaker, and he reviews them also. So I guess I would say, my suggestion would be, you want to explain what the bill says, and your sort of party or your side's, so to speak, view on the bill. My suggestion would be to both sides that it be in a kind of respectful and non sort of confrontational manner. Yes, Representative Tripp.
When we finish the report, who do we submit it to?
Submit it to you submit it to me, and if you're in the Democrats would submit it to Representative Smith at least first, and then it would come to me, but it should go to her first for her review. And this is what I'm going to suggest is the bills we're executing today. I'm going to ask that if we have that the reports from both sides be in by the close of business this Friday. That will allow us to make sure that it can get into the record so that it can be put on, it can be put in the calendar for next week and then go on the next.
You might want to make it noontime.
But you can't,
Oh,
Noontime Friday.
noontime.
but of course, it can't go into the calendar.
Well, that's right. No, I'm sorry. It would be the calendar for the following. Would be the calendar. Yeah. So if you, right.
So, yeah, for the next week would need to be Thursday end of business.
Right, right. But I guess I'd like to, just so that it gives everyone time for us to review it, the speaker to review it. And again, I would request that you have the reports in by this Friday at the close of business.
You're much more generous than I would.
Yes, Representative Wallace.
Thank you, Chairman Lynn. It might make sense, since most of us are pretty organized, we know the motions we're going to be make. I would suggest that if you think you might be making a motion on a particular bill, have the blurb written and with you. That way you're off the hook. When we're done, we're done. Make sense?
All right. Does anybody have, yes, Representative Stapleton?
On these blurbs or
Committee reports.
reports, is there a form available in the office, or is it an online that we can obtain the form?
Clerk
Okay,
will give you the,
There used to be a form to do that. It was a blue or a yellow sheet, depending on the majority or minority. But it can be, you can just do an email template and write your paragraph, a couple of sentences, touch on your points, and you can just submit it directly like that without a form via email.
but does Caitlin have a form to give?
Caitlin does have, yes, Caitlin does have. Yeah.
And Mr. Chair, do you want us to send the reports to you directly or to the secretary?
Actually, I would copy both of us on it. And again, for the Democrats, you should send your report to Representative Smith alone first, so that she gets to review it and make, she may have suggested changes or whatever, and only after she's done reviewing it, should it come to me. So it goes, each side sort of submits their reports through the chain of command, so to speak, to their side, and then once their side is satisfied with it, then it'll go to me, and then go to the speaker. Anybody have any questions on any of that? All right. Then first, I'm going to turn to HB 67 FN relative to the right to review source code of software in criminal cases, and I will recognize Representative Stapleton for a motion.
I move ITL on HB 67,
I second
believing
that.
that
But first, let me just ask, is there a second? Representative Alexander seconds? All right, yes, discussion. Representative Stapleton.
Yeah, I think it's too fine and too narrow of a need, and not many people are capable of looking into source code without third-party assistance, and I just, it doesn't make sense. It doesn't seem practicable for value in criminal cases or evidence.
Other people, any other comments on this of any kind? I guess I would just say very briefly that, as was pointed out at the hearing, the courts have authority to order the production of source codes in particular cases if there's some basis to believe that there's a problem with source codes. This bill would sort of make it like just sort of automatic that source codes are available. It would, as was stated at the hearing, it would present issues of intellectual property rights of people who own the source code, so to speak, third parties. So I think Representative Stapleton's motion is very well taken. Other people, anyone else have any comments on it? Are we ready for a vote? All right. Then I would ask for a roll call vote on this and ask the clerk if she would please call the roll.
On the motion of ITL for House Bill 67-FN, Rep. Wallace,
Yes.
Rep. Alexander,
Yes.
Rep. Andrews,
Yes.
Rep. Testerman, Rep. Stapleton,
Yes.
Rep. Tripp,
Yes.
Rep. Greason,
Yes.
Rep. Kutab, yes. Rep. Seidel,
Yes.
Rep. Smith,
Yes.
Rep. Corrigan,
Yes.
Rep. DiLorenzo,
Yes.
Rep. Schultz,
Yes.
Rep. Rung,
Yes.
Rep. McBeath, Rep. Devine,
Yes.
Rep. Lanza,
Yes.
Rep. Manos,
Yes.
Rep. Turer,
Yes.
Chairman Lynn.
Yes.
The motion passes 20-0.
Motion move to consent?
All right, and, I'm sorry. Yeah, it's even A. All right, so, it's a 20-0 vote. Although it has an FN, since it's an ITL motion, I think it can go on the consent calendar.
Yep.
Does anybody have any objection to it going on consent? All right, so we'll put that on consent. Next, and this we take up HB 290, and I guess before I recognize Representative Wallace for a motion on that, I want to bring something to the this was this was one of the bills that, when I spoke to Representative Smith, there was, it appeared that there would be a disagreement between the majority and the minority. The majority was inclined to recommend this ought to pass. And I apologize for this, for not catching this earlier, but here is what I'm very concerned about. As if you look at this bill, which seemed like a very simple bill, it proposed to allow constables to make service of process of writs that were in excess of $75. And I think all of us, at least on my side of the aisle, sort of thought, what's the big deal if we change this? There didn't seem to be any particular opposition to this bill as opposed to 187, which we'll get to in a moment. The thing that caught my eye about 4 o'clock this morning was the language in the bill that says the constable shall. And so then the question became, what is a constable? So after calling Richard Head at the judicial branch and doing some research myself, I came across RSA 105.3, and I'm quoting it to you now. It says, all police officers are, by virtue of their appointment, constables and conservators of the peace. What that means, it seems to me, is that police officers are constables, and if we were to pass this bill, we would be saying that police officers could be ordered, presumably at the request of a party, to serve writs that would be above $75. So presumably, a lawyer, instead of going to the sheriff, could go to a police officer with a writ for in a $3 million civil suit and say, you have to serve this writ. I think if we were to pass this, we would be effectively nullifying what I think would likely be a motion to ITL 187, which is the next one. So my suggestion is that we should join with our colleagues on the, I'm speaking to the Republicans here, join with our colleagues on the other side of the aisle in moving this be ITL. But I'm happy, if people have a different view on it, I'm happy. I don't want to, that's my view. If people have a different view, we should discuss it. All right, so then I would entertain a motion to ITL 290. You have a motion on that or no?
So moved.
All right. We have a second? Second? All right. Any further discussion on House Bill 290? All right, and as I say, I apologize to my colleagues. I should have caught this earlier and I didn't, and but I'm glad I caught it at least before we voted. So it looks like there's no further discussion. So then on the motion for ITL on House Bill 290, I think we're ready for a vote.
Rep. Wallace,
Yes.
Rep. Alexander,
Yes.
Rep. Andrews,
Yes.
Rep. Testerman, Rep. Stapleton,
Yes.
Rep. Tripp,
Yes.
Rep. Greason,
Yes.
myself, Rep. Kuteb Clerk, yes. Rep. Seidel,
Yes.
Rep. Smith, Rep. Corrigan,
Yes.
Rep. DiLorenzo, Rep. Schultz,
Yes.
Rep. Rung,
Yes.
Rep. Macbeth,
Yes.
Rep. Devine,
Yes.
Rep. Lanza,
Yes.
Rep. Manos,
Yes.
Rep. Turer,
Yes.
Chairman Lynn.
Yes.
The motion of ITL passes 20-0.
And again, is there any reason that this cannot go on the consent calendar? Anybody have an objection to that? All right, so it was seconded by Representative Tripp. And so we'll place that on the consent calendar. All right, next, we move to HB 187 FN. And
He goes in his order. It's a similar bill.
oh, it's a similar bill. I put them together because it's a similar bill.
But it's, which bill? It's not on this list for bills that we're execing today.
No.
Oh, it is?
Oh, I mean, oh, I'm sorry, it is. I see where it is.
Okay, okay, all right. So HB 187, I put those next to each other because they deal with really the same subject matter effectively. So HB 187, permitting a police chief or other designated law enforcement officer to serve process. I recognize Representative Stapleton for a motion.
I move that this bill be ITL.
All right, is there a second?
I second the motion.
Seconded by Representative Andrus. Is there discussion
Stapleton, I guess.
on the bill? Any discussion? Are we ready for a vote? Representative Stapleton, yes.
Yeah, I believe this bill is properly ITL. We're short of police, state police, and even sheriff's department. And saddling local police officers with process serving is counterproductive to mission and goals and safety and public safety. It should remain as it is now with the sheriff and other appointed officers for that.
Any other discussion on HB 187 FN? Seeing none, I think we're ready for a roll call on that. I'll ask the clerk to call the roll.
On the ITL motion, Rep. Wallace,
Yes.
Rep. Alexander,
Yes.
Rep. Andrews,
Yes.
Rep. Testerman, Rep. Stapleton,
Yes.
Rep. Tripp,
Yes.
Rep. Greason,
Yes.
myself, Rep. Kutab, yes. Rep. Seidel,
Yes.
Rep. Smith,
Yes.
Rep. Horrigan,
Yes.
Rep. DiLorenzo,
Yes.
Rep. Schultz,
Yes.
Rep. Rung,
Yes.
Rep. Macbeth,
Yes.
Rep. Devine,
Yes.
Rep. Lanza,
Yes.
Rep. Manos,
Yes.
Rep. Turer,
Yes.
Chairman Lynn.
Yes,
The motion passes 20-0.
all right. And again, is there any reason that this cannot be placed on the consent calendar? Anybody have a problem with that? All right, it'll be placed on consent. Next, I will turn to HB 162. And I'm going to recognize myself for a motion of ought to pass. And let me get there, but I'm going to propose an amendment. Hang on one second.
I second that, Mr. Chair.
All right, hang on, let me just find the amendment. No, we're gonna vote on the amendment first. So, I have amendment 116H. Everybody should have a copy of that. It's a very minor amendment. This essentially takes out of existing law the subsection B in 464D:7, Roman numeral 3, to read as follows. It basically, right now in existing law, there's sections A, B, C, D, and E. This proposes to remove what is referred to as subsection B and is in brackets omitted, and just renumber the other ones. Who seconded that? So I move that amendment, and yeah, I think yours.
That's right.
May I ask a question, Mr. Chair?
Yes, certainly.
Just a point of clarification. So what the paragraph that reads the agreement is dated would become subparagraph B, little b.
Yes, it would be. That's right. That would become B. That's right. Yes. Yep. Any other questions? Yes, Representative Horrigan.
I actually, and of course, this was not exactly the most interesting thing ever done is trace the legislative docket of the bill. And it appears what happened is simply that there was a drafting error during a conference committee report because the House and Senate passed different versions of it. And this was supposed, probably would have been normally been caught in the enrolled bill process, but for whatever reason, that particular this particular problem fell through the cracks. And the conference committee report, it skipped straight from B to D without that little omitted thing in there or anything. So we're just correcting a minor technical error that should have been caught earlier in the process, but better late than never. So.
All right. Any other comments on the amendment 116 to HB 162? So are you ready for the question?
Who moved the amendment?
I did. I
I
second.
second, and Wallace second.
Well, second. All right, are we ready for the question? So we can do this by voice vote. All those in favor say aye. Aye. Any opposed? All right. So now we move to the main motion of ought to pass as with this amendment. And are we, is there any further discussion? Anybody have any questions, want to debate or talk about anything? All right. Then I think we're ready for the roll call on HB 162, motion ought to pass as amended. So I'd ask the clerk to call the roll, please.
Rep. Wallace,
Yes.
Rep. Alexander,
Yes.
Rep. Andrews,
Yes.
Rep. Testerman, Rep. Stapleton,
Yes.
Rep. Tripp,
Yes.
Rep. Greason,
Yes.
myself, Rep. Kutab, yes. Rep. Seidel,
Yes.
Rep. Smith,
Yes.
Rep. Horrigan,
Yes.
Rep. DiLorenzo,
Yes.
Rep. Schultz,
Yes.
Rep. Rung,
Yes.
Rep. Macbeth,
Yes.
Rep. Devine,
Yes.
Rep. Lanza,
Yes.
Rep. Manos,
Yes.
Rep. Turer,
Yes.
Chairman Lynn.
Yes.
DOTPI motion passes 20-0.
Any reason that this could not be put on consent?
No objections.
All right. Seeing none, and that will be on consent. All right. All right. Next, I turn to HB 164 relative to prohibiting towns from criminalizing the right to peacefully and orderly assemble. And the chair recognizes Representative Kutab for a motion.
I make a motion to ITL.
Is there a second?
Me, Mr. Chair. Rep. Alexander. Second.
Seconded by Representative Alexander. Representative Kutab, do you want to discuss the basis of your motion?
We had the research person look into this, and it was found that there was a case that went through the Supreme Court, and they determined that it was constitutional to limit protesting as long as it was the scope of it was clear, and that you were still allowing protesting somewhere else. And so it was well defined that it couldn't, be in front of a residence. Then it was considered that it wasn't unconstitutional.
Yes, Representative Horrigan.
Well, something happened a lot. We were being asked to legislate on the basis of a single anecdote, and I was not necessarily confident that everything the proponents of this bill said was necessarily 100% accurate. I mean, even so, in any case, and even if everything they said was correct, I'm not sure if it was improperly handled, and we would have needed like a wider range of instances before tampering with the law, in my opinion. So.
Yes, Representative Stapleton.
Was that court case SCOTUS or was that state court?
SCOTUS.
Thank you.
SCOTUS. Any other comments? So I guess what I want to say, I really want to give kudos to Representative Kutab on this because my inclination, and I talked to Representative Smith, and I don't want to put words in her mouth, but I think at least she was sort of thinking this, is that I had real question about whether the First Amendment would allow a this kind of local ordinance. And fortunately, Representative Kutab went and got the Supreme Court case that specifically deals with this. I asked our researcher to make sure that it was still good law, so to speak, and it is. And there's a Supreme Court case that's really very closely on point from 1988, saying that these kind of ordinances or laws can be valid, and the basic rationale for them is if the ordinance is limited to prohibiting picketing in front of somebody's residence, that's okay because there's a privacy interest in the residence. And in other words, the law generally is that if somebody's speaking and saying something you don't want to hear, you can just walk away. But if it's in your house, if they're picketing outside your house, that the house is supposed to be your sanctuary. So where do you walk then if it's in front of your house? And that's the rationale for this Supreme Court case. The other thing I should say here is I remember very distinctly that the sponsor of the bill told us at the hearing that the trial court in the case that he referenced from over in Newfields had not reached the constitutional issue. Well, in fact, the trial court did reach the constitutional issue, and if you've had a chance to read that decision, it was a 20 plus page decision. This was not some, motion denied. It was a very well thought out decision by Judge Hall, and I thought very well reasoned. So for all those reasons, I think that ITLing this bill makes sense. Representative Oregon.
The other thing was, another aspect of this situation was the official in question. We don't really have very tight security around him, but it would be reasonable to have a security perimeter around him in certain situations. And in fact, the same official canceled. The governor canceled his moved his inaugural speech to a TV studio precisely because he had security concerns about holding it at the State House.
Mr. Chair, I don't think that's relevant to the bill. I don't think it's in the bill.
No.
I tend to think you're right.
Okay, sorry, but
That's all right. Representative Tur, you wanted to say something.
Just adding on, I also think that outside of the provisions that Representative Kutab, uncovered, there is a constitutional prohibition of, establishing ordinances that just in general, as the bill's titled, criminalize the right to peacefully assemble. So I feel like both things are true.
Yes, no, I agree with that. I think there apparently there are some cases that say, if you're picketing not just in some particular house, but you walk along the block or whatever, that might be a different situation. Yes, Representative Wallace.
And thank you for taking my question. What was the name of that case? Frisbee v. Schultz, was it? Schultz, okay. Frisbee, it's a 1988 U.S. Supreme Court case. Still good law. And one follow-up? Yes. Now, the individual involved or the parties involved in that case, were they elected public officials or were they private individuals? What was the nature of that case? Because I believe it has bearing.
I honestly don't remember if they were a public official or
we
not.
don't have the expectation of privacy that a member of the general public does, being that we're elected officials.
It was a doctor that had an abortion clinic.
Yeah, although I'm not, I guess it's targeted at a particular individual. I still, it's a particular individual's house. I'm not sure that, even a public official doesn't have some ability to have a sanctuary. I agree. It can make a difference. I definitely agree to that, but,
Just
yes.
where we've defeated online bullying bills against politicians historically in this House very recently, this is kind of a parallel course.
Okay. Representative Smith.
I have a question for which I don't know the answer, and I guess it has two parts. One is, the home at issue here is the home of an elected official where, the elected official resides with his family, who are not public officials. And the elected official does have an office which is available to the public, to express opposition or concern about his decisions. And of course, I don't even play a lawyer on TV, but I think those are also relevant factors, at least in the circumstances, if not the law.
Right. No, very, I would say very relevant. I guess to me, what I would tend to say is that, to the extent that the rationale for this bill was, there's an ordinance in this town and, arguably others, that is sort of blatantly unconstitutional. We need to have a statute to kind of correct that. It seems to me that is not true. Now, there may be, maybe there would be some sort, as Representative Turer pointed out, maybe, if somebody were picketing and they were picketing along the block as opposed to that particular house, that might raise a question as to whether or not the ordinance could be applied. But I guess I would say that for us to pass this statute would really not make a lot of sense, given that that the ordinance is at least not, facially unconstitutional. That would be my view. All right. Any further discussion by anyone? Yes, Representative Di
Thank
Lorenzo.
you, Mr. Chair. I also felt very strongly that it was a town problem, and if the town people didn't like the ordinance, then they could pull it back.
It's a very good, excellent point. That's a very good point. Other discussion? All right, are we ready for the question? All right, then I'd ask the clerk to call the roll, please, on the motion to ITL House Bill 164.
Rep. Wallace,
Yes.
Rep. Alexander,
Yes.
Rep. Andrews,
Yes.
Rep. Testerman, Rep. Stapleton,
Yes.
Rep. Tripp,
Yes.
Rep. Greason,
Yes.
Clerk, yes. Rep. Seidel,
Yes?
Rep. Smith,
Yes.
Rep. Horrigan,
Yes.
Rep. Di Lorenzo,
Yes.
Rep. Schultz,
Yes.
Rep. Rung,
Yes.
Rep. Macbeth,
Yes.
Rep. Devine,
Yes.
Rep. Lanza,
Yes.
Rep. Manos,
Yes.
Rep. Turer,
Yes.
Chairman Lynn.
Yes.
The motion to ITL passes 20-0.
And is there any reason that this could not also be put on the consent calendar? Anybody have a problem with that? All right, it'll be put on consent. Next, I would turn to HB 169, relative to termination of guardianship, and I recognize Representative Kutov.
I make a motion to adopt the amendment in OTPA with amendment.
All right, and what is the amendment? I know we have it here, but I don't have it right in front of me.
Yeah. The amendment is 2023-0134H, and it was just removing the change in section B and only changing in section C from a preponderance of evidence to clear and convincing evidence.
Does everybody have that amendment? Oh, okay,
Email, yeah, I emailed it out to everybody.
okay. Oh,
We don't.
so it was sent, okay. So did, yes, Representative.
Don't have the amendment.
So, it was sent ahead of time to the committee
Right.
to evaluate, and I think just in the future, if you're proposing an amendment, just have copies printed for the committee just in case. That's all.
Yeah, does any, oh, yeah, would you mind? That'd be great if you, yeah, it could. Oh, yeah, here we go. We have one there.
Hey, somebody's prepared.
All right.
Mr. Chair, could you
Yes.
explain to the non-lawyers the difference between preponderance of the evidence and clear and convincing?
Yes. So preponderance of the evidence is the standard that is typically used in a civil case, like let's say an automobile accident or a breach of contract. And essentially it means 51% for lack of a better term. The way it's usually explained in court is, the scales of justice, there are two scales. Typically what a judge will say is that to sustain, whoever has the burden of proof, to sustain the burden of proof, the party with the burden has to tip the scales ever so slightly in that party's favor. If they tip the other way, or more importantly, if they remain in equal balance, then the burden has not been sustained if the burden is preponderance of the evidence. Clear and convincing evidence is a significantly higher standard of proof. It's, if to use the analogy, it's not proof beyond a reasonable doubt, which is the criminal case. It has to be really, skewed in favor of guilt. But it's somewhere in between preponderance of the evidence and proof beyond a reasonable doubt, which means it's got to be, very clear that the person with the burden of proof has sustained the burden of proof.
Thank you.
All right. Do you want to speak to your amendment or the underlying motion?
Yeah, so in the reason that I made the amendment was DCYF had come out and stated that they basically needed the change in section B not to happen, but they were neutral to the change in section C. And I'm in support of passing it. I do feel like the burden of proof shouldn't be higher for a stranger than it is for a grandparent. And I think that we need to think about the best interest of the child and the fact that this child may be ping-ponging around. The woman who spoke at our session did contact me afterwards and let me know that her granddaughter has since been pulled from the father again. So that child was in the custody with the grandmother for, I believe she said it was like 6 years, then went back to somebody that she barely knew for 3 weeks and then was pulled again. And it's just a lot, I think, for a child. And I really feel like in the best interest of the child to make sure that the evidence is correct, that they're in the right place.
Other comments on, yes, Representative Devine.
There was one, I don't remember who made the statement, and this is the only thing that I could pull out of this, was on line 9 of the original document that we got. It had grandparent or guardian, and I was hoping that somebody, and then further in it was any sort of abuse, not just substance abuse, to have an amendment made for that. And I don't know I don't know if we should do that, and I'm not sure what the correct way to go about it is. And I think on your amendment, on line 6, everything that you have there on line 6 is fine, but grandparent should be also / guardian, and then substance abuse should be maybe substance abuse or any abuse. Yeah, and
So would you be okay, I guess, instead of saying / or any guardian, family member? Because I think it's different when somebody, my thought is that when you take a foster child in as a stranger, you can kind of distance yourself a bit and not get that emotional attachment, right? But when it's your family member, when it's your grandchild, when it's your niece or your nephew, it is so hard not to get attached, and for them to get attached to in the family, like to, their cousins or whomever else may be living in the home.
yeah, I'd be fine with that. I understand the grandparent now better. I just know that these were questions that were raised during when we had committee hearings, and I just wanted them to be addressed again. And two, somebody, like I said, had said any sort of abuse, not just substance abuse, because abuse could be a number of things. And I just think maybe there should be that amendment added.
Yes, Representative Smith. Oh, all right, Representative Macbeth.
Thank you. So I appreciate the work on this bill, and I My concern is that if the grandparents have a higher, I mean, if the parents have a higher standard they have to meet when the grandparents are the guardian, I mean, it might prevent them from entering into the parents entering into the guardianship in the first place, because a lot of the times, I mean, we need this good communication between the parents and their parents and the child. And, I don't understand the reasoning why, if it's a grandparent that's taking care of the child, that it'd be harder for the parents to get the child back to exercise their parental rights. And, so I'm worried about that.
Yes, Representative Stapleton.
I'd like to speak on that. The bill is specifically tied, that level of evidence, clear and convincing, is specifically tied to the parent's substance abuse or dependence. The phenomenon of grandfamilies, which was the subject of a bill some few years ago by Senator Hennessy out of Lebanon, recognizing that so many parents are deficient in the upbringing of their children because of substance or alcohol abuse, that the grandparents are the first line of defense, natural for them to take care of their grandchildren family. And I really applaud this amendment relative to focusing on substance abuse, which we know is very, very difficult to overcome. I know people who are grandfamily parents for children who are substance abusers. And it's very difficult for them to get out of that condition and stay out of it. There's relapse, and I think this hits a nail right on the head.
Yes, I think Representative Manis, and then I'll get to Representative Tur.
This bill is under termination of guardianship, and I find it troubling that we would have two different standards for terminating guardianships. And I think we should have the same standard, which I think should be clear and convincing in both sections. So I would oppose the amendment in the sense that it sets two standards, two different evidentiary standards.
It actually fixes it to set it to be the same standard.
Paragraph B currently says clear and convincing as it's written now, and I took the change out so that it's not changing it to a preponderance of evidence.
So both
Both B and C will both
Yes.
say clear and convincing now.
I think the standard should be a preponderance of the evidence in both paragraphs.
All right, so other comments? Representative Tur.
Yeah, I just want to say I do agree with the comments that Representative Devine mentioned, that it does seem sort of odd to have a provision that just carves out grandparents and just carves out substance abuse when there's a whole range of situations that would be covered. And I do, however, think that moving it to clear and convincing, given the fact that this is, a minor that got placed into guardianship because of some sort of abusive or difficult situation, that, the idea that it would be just a minor tip of the scales between whether it's right or wrong to return that child to the parent, yet especially when they're not in agreement that the child should go back, seems like a too low of a standard.
Yes, Representative Smith.
Thank you, Mr. Chairman. I'm sitting here listening to some very thoughtful responses to the incredibly hard work that our clerk has already put into this. I wonder if I could suggest that Representative Kartab and perhaps 2 or 3 other members of the committee could form an informal ad hoc subcommittee to look at this and come back to us on Wednesday with an amendment that perhaps answers some of the concerns or at least clarifies what people are thinking about it. Would that be something that the chair would entertain?
Absolutely. I think that's an excellent suggestion. The only one other thing that I would say on this, and I want to note here that, if this were going to be and ought to pass as amended, by Representative Kutab's amendment, I told my caucus last night that I would, if everybody else agreed with this, I would go along with it because I didn't want to be the sort of one holdout. But I do want to say that I am concerned about I have no problem with having clear and convincing evidence in subsection B, where it's the guardian who we're placing the burden of proof on. I am concerned about having clear and convincing in subsection C, placing that burden on the parents, because as Representative Macbeth pointed out, my concern there is that what that means, what we're basically saying there, is that even if the parent could show the court that it's more probable than not that I've cleaned up my act, I'm now a fit parent for the child, that's not enough. The court still cannot return the child to the parents. And my concern on that is really a constitutional one. There is a U.S. Supreme Court case called Troxel versus somebody. I don't remember the name, but it's been around for probably 20 years at least. The basic upshot of that case is that parents have very special rights with regard to their children, and that if a parent is a fit parent, it takes something more than, it takes something more to deprive the parent of the child. And so I have a concern. Please understand, I'm not saying that this is clearly unconstitutional. I'm not saying that at all. I'm just saying that I think there's at least a question about it. And so that reinforces Representative Smith's idea that this is something maybe we should have a subcommittee look at. And you can just, you can at least take a look at that case and see what you think as a result of that.
If you agree, I would like to suggest that perhaps Representatives Macbeth and Manos, who do work in this particular area, might have some special skills that could help and if the clerk is willing to sit down with the clerk, and I don't know who else you'd like to suggest, and it seems to me it could be done in time for Wednesday.
Yeah.
So
I think, and if it turns out, if you get really into it and it can't be, well, then
we can do it another time.
We can do it another time. But
Thank you.
The calendar appropriately to allow that.
Right.
Yeah, exactly. So, is anybody else, Representative Turer, do you have some interest in also being on this subcommittee? You're more than welcome.
I'd be willing to participate. Sure.
All right, great. So then why don't we say, Macbeth, Manos, Kutab, and Turer will be the subcommittee, and will report back to us. Does that sound like
Rep Stapleton.
Oh, I'm sorry, Rep Stapleton, you have a strong interest in this, so I don't want to send you into extra work if you don't want to be involved, but if you do, I think you're more than welcome.
Well, I'm kind of jammed up now with any number of family health and other things going on, and
That's fine.
I can't fit it in.
No, that's fine. So, all right, so is everybody comfortable with that we will not proceed with this bill now, and we'll hear from that subcommittee on Wednesday. All right. All right, so let me then turn to CACR 5, regarding relating to fundamental rights, providing that the Constitution protects the right to marry. And I recognize Representative Alexander.
Thank you, Mr. Chair. I move CACR 5 and expedient to legislate.
Right? Is there a second? No, ITL. Is there a second to that motion, Representative Stapleton?
Yes.
Is that right?
Yes, second.
All right. Right, Representative Alexander, do you wish to speak to the motion?
Yeah, just briefly. I, this looks like a very simple constitutional amendment, but when you start making things simple, things get, I feel like, more complicated. And you know, I I feel like everybody should have a fundamental right to get married. I think the Supreme Court has dealt with this very well. I don't think there's really any assault on the right to marriage by anybody. But I do worry that when we put a question to the voters like this, it might pass, and there'll be some very unintended consequences to that. I mean, I asked during the hearing, what happens when you'd like to marry 2 or 3 or 4 people? Is that your fundamental right? If you'd like to marry a minor, is that your fundamental right? I think that creates a lot more problems than it solves when there really is no assault on marriage or anybody's right to get married the way they'd like to in this state, and certainly not in the country. So although I sympathize with the sponsors' intention of putting this into the Constitution, I think that we already have that right. And I think it's restricted in a responsible way. So with that, I just hope the committee would vote with me. Thank you.
Yes, Representative Tur.
Yeah, I distributed an amendment that if this motion does not pass, I hope I'm saying this right, that we might entertain. And it goes directly, I think, to what Representative Alexander raised, and it emanated from his comments during the testimony. I feel that there are some real flaws in the original proposed bill, particularly as a human right. It would grant it to everyone, and there are no clarifications, and so it would literally probably grant the right to polygamy. It would grant the right to child marriage at any age. It would grant the right to incest. And it seemed as though those 3 sort of flaws could be healed with a simple change to the language. So if you look at the amendment, basically working with OLS, inserted more or less the same phrase in 3 places, and it basically adds the language of any 2 natural persons at least 18 years of age and outside of 1 degree of consanguinity. I hope I'm saying that right. That's a new word for me. And so now would read, the right of any 2 natural persons at least 18 years of age and outside of 1 degree of consanguinity to marry shall be a fundamental right. That actually clarifies those 4 different things. 1, to your point, it says it has to be 2, the number 2, so no more or less. It says natural persons, which might seem like an unnecessary thing, but if you've all seen the movie Her with Scarlett Johansson, we're moving into new eras where people can have relationships with non-natural people, and it also excludes things like animals, which I know are also a concern. 18 years or older, I'll come back to that in 1 second. And then 1 degree of consanguinity is OLS's way of saying second cousin or further, which is the current standard for New Hampshire. So just going to the 18 years and older language, I just wanted to clarify that would not put it in conflict with our current rules regarding marriage, even though some marriages are allowable out younger than that. It just says the right would not be guaranteed at 18, at under the age of 18. So it would still leave the legislature capable of regulating marriages below the age of 18. You know, and I know that there's some current discussion around that. So I just wanted to clarify that and correct me if I'm wrong, but that's my understanding, is that it would not be in conflict, or you know, or any other group that is not covered by the right would still be able to be constrained by or granted any other sort of legislative marriage changes. So I think it places what we'll call the right, since it's a constitutional amendment as a human right, sort of within the bounds of current marriage law. I read all the regulations about the current marriage law, and it basically this would be within all of what we're doing. So with that, I guess I'd say I hope you'd accept the amendment so we can, and I'm not going to speak to the bill at this point, just to the amendment, discuss the bill on those terms.
So any, Representative Alexander?
Thank you, Mr. Chair, and thank you, Representative Tur, for amending it to address some concerns. I worry putting something to the voters that's already a right, because I worry about what the unintended consequence of it will be after. I mean, nowhere in the amendment does it say the right of two consenting adults, right? There's not even like, you don't even have to consent to it. You could just be like, oh, I'm going to marry, somebody that can't even consent themselves, maybe through a disability or other means. So I guess I worry this is going to create more problems than it solves, because there's no roadblocks for people to get married in this state. So it creates more problems than it solves. That's all.
Yes, Representative?
I realize I'm a sub here, so
No, that's all right. Subs can speak too.
great. Thank you, Mr. Chair. I think it is certainly, many people are of the belief that certain laws that are in effect currently could be struck down by the current Supreme Court and in the U.S. Supreme Court. And wouldn't it be an awful thing for people in the granite state if marriage equality was struck down in the courts, since that really strengthened the law for the whole country? Isn't doing this bill with the amendment making sure there isn't a gap because of likely U.S. Supreme Court decisions? There's not a gap in what families would need for their choices by way of marriage. Wouldn't this recognize the fact that, hey, there's a decent enough chance? Why leave future granite staters in limbo when they're eager to marry?
Yes, Representative Stapleton.
Thank you, Mr. Chair. I think the founding fathers in the New Hampshire Constitution is telling, with absence of marriage listed in that document. And I believe that there's a reason for that. When you establish in the Constitution of right in the document, now you're being maybe too specific, and now you're going to have to define all the ensuing variables and possibilities and nuances that's going to come forth. And I think that may have been part of the reason why the founding fathers decided not to enter that into the constitutional document. I also believe that at the time, the reliance upon religious customs, traditions, ethos, beliefs, marriage was considered more in the province of that aspect of human culture rather than some controlling factor by the government. I think we're stepping into dangerous territory here, going into the weeds, and it would only incur more and more of law and clarification and documentation on it, and I would be opposed to the amendment.
Other comments? Representative Tur?
Yeah, I just wanted to circle back one more time on the concept of consent, because that was a consideration. But I think that the difficulty with including a word like consent is that brings in some other statutorily defined terms in terms of what it means to be able to give consent, and seem to further complicate the underlying intent of what this was, which is to guarantee people the right to enter into marriage 18 years or older, which is typically an age where where you can give consent. I do understand your concerns with people who can't, but I don't feel it's in conflict. And so this was introduced by Representative Hines from a different party, and I was hoping that we could come together around the concept and make a statement that this sort of oldest institution, which I do think is under threat, specifically stated in the Dobbs decision by Clarence Thomas, that the Obergefell version of marriage specifically should be revisited. He didn't mention the Loving decision that pertains more directly to him, but they were all tied back to the 14th Amendment privacy interpretation. So I do feel like it's a very present concept that could change, and it would threaten rights that thousands of people in the state have taken advantage of.
So I'm Representative Smith, you would requested
I
a,
wonder if we could just take a 5-minute break.
yes, absolutely.
If the Democrats might like to stretch their legs out in the hall.
Uh-oh. We in trouble.
My legs are feeling particularly Sounds like a fine idea. I think we could all use to stretch our legs.
Uh-oh.
All right.
I feel like I'm going to the principal's office. Oh, jeez.
What's going on, Nate?
Oh, yeah, no. It's so good, but it might make sense. The women accept their release, and it's rise in my country, love. Yeah. A large risk. Yeah, what's the next? Remote Zoom, members who fail.
We're back in session. Representative Greason.
Thank you, sir. I think there is a misunderstanding of exactly what the Dobbs decision did and what it could potentially do.
Excuse me, but the Dobbs decision is.
Ma'am, I'm speaking, thank you.
But
If the chair cuts me off, I'll cut off, but in the meantime,
I think
I think there's misunderstanding of what the Dobbs decision did and what it could potentially do based on the statements that were made in the ruling. What the Dobbs decision did was put the determination of how abortion rights would be determined down to the state level. So each of the 50 states can have their own laws. There would not be one broad federal law. That's per the 14th Amendment of the Constitution. 10th Amendment. I can't remember now. I am not an attorney, constitutional lawyer. However, the Constitution says that the powers that are not delegated specifically to the federal government belong at the state. So when we consider all those other potential brush fires that could emerge, such as the Obergefell or the Loving or any other rulings that may or may not be dealt with, all that would do, the precedent would then be each of the 50 states could make their own laws. That's all it would do. Some states may do one thing, another state may do another thing, And then if there's a conflict, then that would be brought back to the Supreme Court for adjudication. What we have presently, and we're considering CACR 5, is we're trying to prevent something that's not even going to happen. We have a law on the books, and that's whatever the Supreme Court does, they're going to tell us we can do whatever we want. So I don't find that CACR 5, amended or not, is even necessary.
Right. Any other comments? So I guess the only thing I would say is that it does seem to me that there's just, as Representative Alexander said, there's just really no reason for this. I don't there's a threat to the right to marry. I candidly just don't see how where it exists. And bear in mind that this is a state law. This would be a state constitutional amendment if somehow lightning struck and the federal Supreme Court overturned one of those decisions that was referenced. That wouldn't mean that that you couldn't marry. It would simply be turned back to the states. And the state law now, I don't see any suggestion that state law is going to be changed in a way that would in any way interfere with the right to marry, whether it's on a sexual basis or a racial basis or any other basis. So I just don't think that that CACR 5 is necessary.
Mr. Chair, I'd
Yeah.
like to call the question.
Right. Yes. All right. Yes, the question has been called. Is there a second on that, calling the question? I'll second it. I'll second it. All right. So we're ready for a roll call vote on CACR 5, and I would ask the clerk to call the roll, please.
Mr. Chair, just a point of order.
I'm sorry, it's a motion to ITL.
Thank you, sir.
Yes, motion to ITL CACR 5.
Representative Wallace.
Yes.
Representative Alexander.
Yes.
Representative Andrews.
Yes.
Representative Testerman.
Yes.
Representative Stapleton.
Yes.
Representative Tripp.
Yes.
Representative Greason.
Yes.
Clerk, yes. Representative Seidel.
Yes.
Representative Smith.
Yes.
Representative Horrigan.
Yes.
Representative DiLorenzo.
Yes.
Representative Schultz.
Yeah, so she wasn't here, so she doesn't vote.
Representative Rung.
Yes.
Representative Macbeth,
Yes.
sorry. Representative Devine.
Yes.
Representative Lanza.
Yes.
Representative Manos.
Yes.
Representative Turr.
Yes.
Chairman Lynn.
Yes.
It passes 19-0.
All right, and is there any, constitutional amendment can't be put on consent because if we've ITL, so we can put it on consent. All right. All right. Anybody object to this being put on the consent calendar? All right. Next, I'll turn to HB 240 and recognize Representative Alexander for a motion.
Thank you, Mr. Chair. I move HB 240 in expedient to legislate.
Is there a second? Representative Kutab.
A second.
All right. Representative Alexander, if you wish to speak to your motion.
Yeah, thank you, Mr. Chair. A lot of what I'm going to say or what I would have said, I said on the last bill. I think it's still the same. I support marital freedom, and this is the Marital Freedom Act, but I don't think there's any obstruction to marital freedom in this state, so therefore I just don't think we need this bill. So I hope that you'll join me in ITL it. Thank you.
Anyone else wish to speak on HB 240? All right, are you ready for the question? I would ask the clerk to call the roll, please.
On ITL House Bill 240, Rep. Wallace.
Yes.
Rep. Alexander.
Yes.
Rep. Andrews.
Yes.
Rep. Testerman.
Yes.
Rep. Stapleton.
Yes.
Rep. Tripp.
Yes.
Rep. Greason.
Yes.
Clerk, yes. Rep. Seidel.
Yes.
Rep. Smith. Rep. Horrigan.
No.
Rep. DiLorenzo.
No.
Rep. Schultz.
No.
Rep. Wrong.
No.
Rep. Macbeth.
No.
Rep. Devine.
No.
Rep. Lanza.
No.
Rep. Manos.
No.
Rep. Turer.
No.
Chairman Lynn.
Yes.
The motion fails 10 to 10.
All right. Is there another motion?
Mr. Chair,
Yes.
I move to retain HB 240.
All right. HB 240, there's been a motion to retain, and it's been properly seconded by Representative Wallace. Is there any discussion on that motion? Representative Manos.
Just a question, what would be the purpose of retaining it?
Representative Alexander.
It's clear that the committee's divided on it, so, the other motion would be ought to pass, and I don't see that would pass either this committee, so I think retaining it and working on it this summer would be a good idea.
Any other comments on the motion of ought to pass? I'm sorry, I've retained. So are you ready for the question? All right, I would ask the clerk to call the roll on a motion to retain House Bill 240.
Rep. Wallace.
Yes.
Rep. Alexander.
Yes.
Rep. Andrews.
Yes.
Rep. Testerman.
Yes.
Rep. Stapleton.
Yes.
Rep. Tripp.
Yes.
Rep. Greason.
Yes.
Clerk, yes. Rep. Seidel.
Yes.
Rep. Smith.
No.
Rep. Horrigan.
No.
Rep. DiLorenzo.
No.
Rep. Schultz.
No.
Rep. Wrong.
No.
Rep. Macbeth.
No.
Rep. Devine. Rep. Lanza.
No.
Rep. Manos.
No.
Rep. Turer.
No.
Chairman Lynn.
Yes.
Motion fails 10 to 10.
Is there another motion?
Ought to pass.
Is there a second?
I second it.
Anyone wish to, the motion now on the floor is ought to pass. Is there, which has been seconded, is there any further discussion on that motion? Seeing none, I'd ask the clerk to please call the roll on motion of ought to pass.
Rep. Wallace.
No.
Rep. Alexander.
No.
Rep. Andrews.
No.
Rep. Testerman. Rep. Stapleton.
No.
Rep. Tripp.
No.
Rep. Greason.
No.
Clerk, no. Rep. Seidel.
No.
Rep. Smith.
Yes.
Rep. Horrigan.
Yes.
Rep. DiLorenzo.
Yes.
Rep. Schultz.
Yes.
Rep. Wrong.
Yes.
Rep. Macbeth.
Yes.
Rep. Devine.
Yes.
Rep. Lanza.
Yes.
Rep. Manos.
Yes.
Rep. Turer.
Yes.
Motion fails. Oh, sorry, Chairman Lynn.
No.
Motion fails 10 to 10.
So so the bill will go to the floor with no recommendation. Rep. Alexander, I would ask you to write the report for the ITL, and Representative Smith, Representative Macbeth, can you write the report for ought to pass? All right. I'm just, hang on one second. Okay. All right. All right. Moving on then to CACR 6, relating to the retirement age for judges, providing that mandatory retirement age, the judicial retirement age shall be increased from 70 to 75. The chair recognizes Representative Kutab for a motion.
I motion ought to pass.
All right, is there a second? All right. Is there discussion on the motion? I guess I would like to just briefly say, for the reasons I've stated before, I think that it does make sense to increase the judicial retirement age to 75 for the reasons I said at the hearing, and I won't sort of belabor it, but I'm happy to answer questions if anyone wants to discuss it further or has questions about it. Okay, right. And Stapleton seconded it. Is there, so are we ready? Are we ready for the question?
Yeah.
All right, I would ask the clerk to call the roll, please, on CR 6.
For the ought to pass motion, Rep. Wallace,
Vice Chair votes yes.
Rep. Alexander,
No.
Rep. Andrews,
Yes.
Rep. Testerman, Rep. Stapleton,
Yes.
Rep. Tripp,
Yes.
Rep. Greason,
Yes.
Clerk, yes. Rep. Seidel,
Yes.
Rep. Smith,
Yes.
Rep. Horrigan,
No.
Rep. DiLorenzo,
Yes.
Rep. Schultz,
Yes.
Rep. Rung,
Yes.
Rep. Macbeth,
Yes.
Rep. Devine,
Yes.
Rep. Lanza,
Yes.
Rep. Manos,
Yes.
Rep. Turer,
Yes.
Chairman Lynn.
Yes.
Motion passes 18-2.
No, yeah, it has to go on the regular calendar because it's a constitutional amendment.
I will not be writing minority report.
All right. All right. Representative Kutab, you would write. Oh, that's right, the majority.
Okay,
If you
18.
if you want me to do it, I'm happy to do it. That's not a problem.
Okay.
All right.
So,
You'll Biden it.
ought to
Oh,
pass
that's it, yes.
18-2.
All right. Turning to House Bill 663. Hang on. Chair recognizes Representative Greason for a motion.
Mr. Chair, I move that House Bill 63 be found inexpedient to legislate.
All right, is there a second to that?
I second the motion.
All right, yes, Representative Greason, you wish to speak to it?
Oh, yes, thank you. I know firsthand that municipalities use zoning laws to, shall we say, make it extremely difficult for religious institutions to utilize their properties. That being said, I don't think this bill actually fixes that problem and may, in fact, even with the amendment that Representative Mooney presented, may, in fact, present a situation where it looks like religious institutions would not even be subject to zoning laws. There is no explanation of what it means to provide housing for the unhoused. How long are we talking about housing them? What type of housing is it? There's a difference between a homeless shelter and apartment complexes or quadplexes or anything like such nature. So because of some vague language, and believe me, I'm sympathetic to the cause, I think that there needs to be some assurance that municipalities are not using zoning laws to put unnecessary hindrances to religious organizations from exercising their rights. But I just don't think this bill is actually it, unfortunately.
Anyone else? Yes, Representative Manos.
Thank you, Mr. Chair. I share concerns about the bill, but for different reasons. But I was going to suggest that we retain it for study, so that we could address some of the issues that I think we might have as a committee with this. I'm concerned about the language of substantially burden religious exercise and that language invites litigation. I'm concerned about the entanglement of church and local government. Who decides? Who has the burden of presenting evidence? What's the burden of proof? That's not defined in the bill. And then finally, the list that's provided is not either exhaustive or all-inclusive of zoning regulations. So rather than ITL, I would like to see this retained for study.
Other Representative Horgan.
Well, I'm also opposed to the ITL. I think actually my preferred option is to delete the entire RSA that this bill amends, and that's something we can do if we overturn the ITL and to move on. That's one of our options. I was this bill passed just last year, and I was opposed to it then, so I understand the concerns behind it, but I'm not sure whether, and it's a club or association that calls itself a religious organization, necessarily deserves special privileges in the zoning law compared to ones that call themselves secular organizations. So I think there's a so I sort of think there's a First Amendment issue here. And also the original bill too is also an anecdote involving a particular religious organization in Durham, and I'm not sure whether that anecdote was accurate, but I guess that's in the past. But I think so. My preferred option, retaining it, is preferable to leaving it as is, but leaving the law as is. But I think my preferred option would be just to delete the entire RSA. Although I know that's probably a pretty heavy lift given the given where the rest of the committee is. But that's so I'm voting. So I'll be voting against the ITL for that reason.
Yes, I'm sorry. Yes, Representative Tur.
Yeah, thanks. So I also like the idea of retaining the bill because I think the existing statute, as I read it, does have some flaws. One of the zoning board members, McGuire, I think, that came and spoke to us, listed that the existing law, the exemptions that are listed, because it basically grants it and then says, except for all of these things, which are most basic zoning regulations, don't apply. And he said that list was not comprehensive. So I think there's flaws with the current law, but the new law, I like the fact that it narrowed it and said you can't pass a restriction that is solely on the basis of religious purpose, whereas the existing law basically grants it based on the fact that the building itself is currently being used for religious purposes. So it's a very different concept than what the bill said. The bill I like better, but the existing law has holes in it, and so does the bill. So that's why I would think retain.
Anyone else? Representative Smith.
Thank you, Mr. Chairman. All of us know that we are, not just in New Hampshire, but across the country, experiencing a very serious problem in terms of access to housing. And we can come up with myriad reasons for that. But for solutions, I think we're all now looking at Representative Alexander's committee to tell us what the solutions are. So it's all on his strong shoulders. And when he comes up with that, people all across the nation are going to be cheering. I share with Representative Horgan the concerns about the initial bill that passed last time. This is now an attempt to try to correct some of the problems, but there are so many more problems that exist. So the bill itself isn't the answer, but I don't think leaving the underlying legislation as it is the answer either. There is nothing that would make a time difference if we were to act on this now or not. ITL just closes the issue. I would like us to keep the issue open in this committee because we have a responsibility, as do other committees, to address some of these issues. And by retaining the bill, we create an opportunity for us to do some thinking, some deep diving, if that's the appropriate expression, and see if we can actually come up with legislation that addresses the problem, and meanwhile, we won't be adding to the problem by just ignoring it. So I would hope that you would consider the possibility of not accepting the ITL motion and then giving some consideration to a motion to retain. Thank you, Mr. Chair.
Yes,
Thank you, Mr. Chair. As a co-sponsor of this bill and a supporter of the amendment, I also support retaining it so that the sponsors can have a discussion, because I think we're getting in, not only with current legislation, but we're talking about property rights and the separation of church and state to address one of the most severe problems facing New Hampshire and throughout the country. So I think retaining it can bring in some voices and dive deeper into this issue. Thank you.
anyone else?
Mr. Chair?
Yes, Representative Di Lorenzo.
Thank you, Mr. Chair. I am in favor of retaining it, mainly because I went online to look at the opposition and support of the bill from the public, and one person supported it and 370 people opposed it. So I think that I would love to see a deeper dive into this issue. Thank you.
Other comment? Yes, Representative Stapleton.
Thank you, Mr. Chair. I personally don't have a problem with RSA 674. And the last sentence in the bill is displayed: the building of housing to house the unhoused by a religious organization shall qualify as religious exercise under this section. Well, it's a form of charity. Religions of all types and kinds do charitable work for humanity and other people, not only of their own denomination, but generally others. And if they want to build housing, they've got permit and compliance with code and compliance with existing statutes in areas of housing or medical or whatever is going to be involved with the building. So I think we have a body of law that adequately covers how that charity can be manifested under religious charity.
All right. Other comments?
But I would be okay with retain because it gives think time, and I think this is a big enough item that it requires think time, if not a lot of it.
Right. Well, so I guess what I would say is this: I don't disagree with the people that say that this requires some further work, but my concern is, it seems to me that it requires enough further work, so to speak, that it's unlikely we're going to get this done in sort of a retained situation. To me, the people who have questions about should it be changed in one way or another, and I tend to agree with Representative Smith that there are some issues with at least some parts of the current law, but it seems to me that there's nothing that would prevent this from in the next session, next year, somebody coming back with a bill to change the law if there's some reason to do so. As I say that, I guess maybe I ask: are you concerned that if we did that, that there would be we would be prohibited from doing that in the next?
If we did ITL?
Right.
If we did ITL, we couldn't bring.
Anything to do with that.
It would have to be, substantively different to bring it back in this term.
Right. Okay. But I mean, it sounds like what we're really talking about are substantively different things, aren't they? Isn't that really what people are saying?
Yes.
So complicated, Mr. Chair, that I don't know if I can answer that question. I just feel that I listened carefully to what Representative Stapleton said, because I think he made some very good points in his statement, and he was reading from this language saying that he thought it was appropriate as a charitable operation of a religious institution to address the housing issue. I too agree with him, which is why ITL on this bill is of some concern to me, because that language then disappears. And we are left with the existing language, which isn't as focused as this. And so, I think, I mean, not to quote a former president, but I feel everyone's pain on this issue, and I would like to take a crack and see if the Judiciary Committee, which has limited authority in terms of housing issues, after all, we don't have planning and zoning, we're not the municipal committee. I would like us to see if there's a little piece of it that we might contribute to help the problem until we can come up, until Representative Alexander solves the whole thing for us. And that's why.
And to be fair, Representative DiLorenzo will be solving it as well.
Exactly.
All right.
Exactly. I agree with that. And actually, the difference between Representative Alexander and Representative DiLorenzo is that Representative DiLorenzo would be happy to let Representative Alexander take all the credit.
Mr. Chair, if it's appropriate at this time, I would withdraw the motion to ITL and make a motion to retain House Bill 63.
Before you do that, let me just hear from Representative Macbeth, and then I will get to you.
So I greatly respect my ranking member, and I feel like ITL is the best vote for this bill. We have the housing committee special, and I think we should let that take its course. I also think the issues regarding separation of church and state are significant, and that's something that's going to need a lot of work. And as Representative Smith said, housing really is not our main purview. So I would like, this bill could come back whenever, but I first of all would like the housing committee to do its work, and then you know, if somebody wants to bring it back, they can. But I really think ITL is the best.
Right. So Representative Greason, in light of what Representative Macbeth has said, do you still wish to withdraw your?
I know that the motion was made and seconded, so it would also have to be agreed to by the one who seconds it. I think because of the fact that this is such a huge scope problem, I do believe ITL is the appropriate motion and the proper action to take. This is way too big of a problem for this committee to try to solve, even over the summer, as best as our intentions may be. If we have a commission to study this and to try to come up with something, what makes it think that we're going to come up with it over the summertime? I think ITL is the appropriate motion, and if the one who seconds it would still keep the second, then I think the motion should stay ITL, and let's go with a vote for that. If it fails, I'll make the motion to retain.
So that your thinking is exactly my thinking. I tend to think that we should ITL this for the reasons that's been stated, but if that fails, I will also be voting with Representative Greason to retain it. So are we ready for the question on ITL? Any further discussion? All right, I'd ask the clerk to call the roll, please.
On ITL for House Bill 63, Vice Chairman,
Yes.
Rep. Alexander,
Yes.
Rep. Andrews,
Yes.
Rep. Testerman, Rep. Stapleton,
Yes.
Rep. Tripp,
Yes.
Rep. Greason,
Yes.
Clerk, yes. Rep. Seidel,
Yes.
Rep. Smith, Rep. Horrigan,
No.
Rep. DiLorenzo,
No?
Rep. Schultz,
No.
Rep. Wrong,
No.
Rep. Macbeth,
Yes.
Rep. Devine, Rep. Lanza,
No.
Rep. Manos,
No.
Rep. Turer,
No.
Chairman Lynn,
Yes.
motion passes 12 to 8.
Be a minority.
Right, well, if-
Will to be? Who were the two?
Rep Macbeth and Rep Divine.
Oh, okay, Rep. Devon, I'm sorry, I missed that. Thank you.
All right. Will there be a minority report? Well, we kind of, I mean, yeah, I mean, if you, I guess really it's a question for you, Representative Smith. If you're fine with that, then I'm fine with it too.
Okay, well, why don't we say that we'll let you know within 24 hours?
Sure, that's fine. Okay. All right. Okay. All right. All right. Next, we turn to our last bill for today is House Bill 256, prohibiting cities and towns from discriminating in the use of public facilities. And I will recognize myself for a motion on that and present first an amendment, which you all should have. It's Amendment 2023-120H. Which you'll see I think it clears up, at least in my mind, it clears up what I thought was some troubling language in the original bill. I should say that I've discussed this with Representative McGuire, who was the prime sponsor of the bill, and he was fine with this language. It's designed basically to say that, well, let me just read. No municipality shall discriminate against any individual or group in the use of municipal facilities for a lawful purpose. So it's got to be a lawful purpose. If you're proposing to hold a meeting to talk about let's overthrow the government, or let's go burn down some houses in some neighborhood, that's not a lawful purpose. But assuming it's a lawful purpose, there can be no discrimination on the basis of the subject matter to be addressed or the viewpoint to be expressed by the individual or group. It goes on to say that a municipality may, however, impose reasonable and non-discriminatory time, place, and manner restrictions on such use, and assess reasonable fee. This was another point that was not in the original bill. And assess reasonable fees for the use, provided that such restrictions and fees are applied equally to all users of the facilities. It seems to me that that language, the time, place, and manner allowance of those kind of restrictions makes sense. It's certainly the Constitution would allow that. And so I think that this will help to ensure that municipalities sort of treat everyone equally and don't have a situation where, if you have this viewpoint, it's okay to have to use public facilities, but if you have that viewpoint, it's not. So for those reasons, I think it's. I hope that you will support. I hope you will support this amendment. Yes, Representative Macbeth.
So thank you. So I have two questions. One, you said, use the example, not overthrowing the government, but doesn't our Constitution guarantee the right to have revolution? And I mean, and I'm asking you because you're the expert. And then also, so I'm concerned about lawful speech because, I mean, the right to be anti-Holocaust all of that's lawful, but that might not, so that can't be discriminated against, and the town has to allow the neo-Nazis or whatever, anybody?
Well, I no, that's an excellent question. I think on the right to revolution, that is in our Constitution. It's not in the federal Constitution. It is in ours. It's never been construed, and it's at least as far as I can recall, and it's it's hard to understand how it ever would be construed to allow, a group to say, we're marching on, we're grabbing our guns and we're marching on the State House this afternoon. I would think that the government would have that the Constitution is not a suicide pact, I guess I would say. So I would think that and I guess the other thing I would say is if that provision applies, it applies in so many, it could be used to apply in so many circumstances to so many laws. I don't know, that motor vehicle laws where, we want to be able to speed because we're exercising our right of revolution and we have to get to the State House right away to overthrow the government. But I think I guess the other point that to the extent you talk about, that you use the Nazi example, I guess what I would remind everybody is, remember Skokie, Illinois, in the late 1970s when the Nazi Party wanted to march through a neighborhood, heavily Jewish neighborhood, and it went to the Supreme Court and they said yes. So, however distasteful, in fact, I think that's really I think in some sense that's part of the problem, is that we've begun to restrict the First Amendment, the exercise of people's rights on the grounds of, I think some people today, my sense is that most people, when Skokie was decided, and I think it was 1977, said, as much as we hate what the Nazis are standing for, we agree that they have the right to do this, to march through Skokie, Illinois. And I'm concerned that we've begun to narrow our conception of what is constitutionally allowed. And I think that really is a problem, because it becomes, speech. I don't in any sense condone what happened on January 6th, but for the idea that that the president couldn't, that the president couldn't go to, let's suppose that he wanted to go and hold a rally a couple of weeks later in a municipality in New Hampshire, that the municipality could say, well, look what you did on January 6th. You can't come here to have to peacefully speak about whatever. That kind of concerns me.
So I misspoke. I shouldn't have said Nazis, because I understand that. I'm not talking about just not liking speech, but I'm talking about misinformation and stuff that's not right, like the Holocaust deniers or other things like that. But I'm just clarifying. I'm not going to argue about it. But so you're saying that this bill, you're discounting the right to revolution, which we're talking about free speech. It's not motor vehicles here. We're and municipalities. You're saying any speech, whether it's misinformation, right or wrong, it has to be not just distasteful, but municipalities would have to allow it. They could not regulate the content of it. And we've been regulating the First Amendment for hundreds of years. I mean, you can't yell fire in a crowded theater and a lot of other things like that. But I just want to be clear with you. You're supporting this and you're agreeing that no content can be, whether it's wrong or right or distasteful.
Well, no. I'm not saying that. I'm saying reasonable time, place, and manner restrictions. It seems to me that and lawful purpose. It seems to me that if you are saying, if what you propose to do is the equivalent of yelling fire in a crowded theater, or pornography, or that kind of thing, the traditional things that have been held not to constitute a lawful speech, that can be regulated. But if it's just, if it's very distasteful, and I think that's, my sense is one of the reasons that sort of animates this legislation is that there has been that view that we, in other words, is the Nazis that wanted to march through Skokie, would that today be called hate speech? What they wanted to do was hate speech, and therefore it could be regulated. Again, as much as I would hate what they say, I would tend to say no. That's not hate speech. Well, if it is hate speech, it cannot be prohibited. And I think that the concern I have is that there's this narrowing of what is the permissible range of speech, and that troubles me a lot. Representative Stapleton.
I encircled on your amendment, lawful purpose. And you linked lawful purpose and followed by subject matter addressed. The subject matter, even if offensive, is a First Amendment. Now, lawful purpose goes to what's the purpose of the of the gathering or activity? Is it to threaten and intimidate? I mean, go back to Skokie. They were probably protecting the First Amendment, as distasteful as that was, but I would bet that there was some overabundance of legal police activity to make sure that they mitigated, threaten, and intimidate nature of that particular march. So I believe the Supreme Court recognized that that was contributory to holding down the threaten and intimidate aspect of it. And that's part of the reason why they ruled as the way they did.
Representative Turer.
Yeah, one of the things that stood out in the testimony on this bill from Representative McGuire, is basically he framed it in that he could have sued the town, he thinks, over, their decision directly, that he felt that it was inconvenient, and that going to the legislature was the better way to go. I also asked him if he thinks he would have prevailed if he sued the town, and he thinks he would have. And I think that may go to this question of, is this already basically, guaranteed based on everything we've talked about, that this really isn't a needed law? It just sort of, based on a particular situation that arose, that we don't know whether the courts would have upheld or not the town's decision. It just sort of short-stopped it and went right to sort of creating new law, and that worries me.
Representative Alexander, I think you.
I did. I just wanted to contribute a little bit. I think we're talking about time, place, and manner, and I think we're confusing that with content. So we have a right to regulate time, place, and manner under the Constitution. I think it's already granted right, but we don't have a right to regulate content, right? And I don't think that we should be able to regulate the content. Just make it safe for everybody to speak and say what they like, even though it may be wrong or disinformation to somebody else. You get 10 flat earthers in the room, you shouldn't restrict them from being able to talk about the earth being flat,
Yes, Representative Greason.
Thank you, Mr. Chair. Is the expression or some similar expression lawful purpose anywhere else in RSAs? That would this be something that attorneys and judges would understand the meaning of the phrase lawful purpose?
I think so. I can't tell you, recite off the top of my head other places, but I believe that, that language or language like that is used in a variety of contexts in the law. Representative Manos.
Thank you, Mr. Chair. In my recollection of Representative McGuire's testimony, he also said that there was one facility that they were authorized to use, and there was another facility, the gazebo or the bandstand, that they were prohibited from using. So I also question whether this is necessary, because he was not being, or the Republican group that he was associated with was not being totally excluded or precluded from speaking in a public place, but it was one specific location. The other thing that concerns me is this does not exclude commercial speech. And so question of whether this would mandate that a municipality, for example, allowed people to use a room at the library to sell their widgets. And I would be concerned about that also.
Okay.
Thank you.
Yes.
Thank you, Mr. Chair. When I was reading the amendment, and I'm sorry, as a sub, I wasn't here for the hearing, but it says no municipality shall discriminate the use of municipal facilities. I see this as a local control issue, that municipalities are elected by their friends, their neighbors, people in that community who know what's the best interest of that community. And I would, I think they are the best judge, not people at the state level, for the proper and appropriate use of their facilities.
Okay, all right, other comments? I guess what I would just say is this: I think that I think with regard to Representative McGuire's testimony, I do agree that that he said, there might have been another place where I could have, but I think the concern was that that some people were allowed to use the place that he wanted to use, but he was, and this is my word, not his, but he was relegated to somewhere else and sort of felt like, wait a minute, why can't some people use this but not me? And I think that's the issue. And in terms of, on leaving it to the local level, well, I think that's part of the problem, is we want it to be equal. Yes.
Thank you, Mr. Chair. Well, one situation that I've been aware of in my town of Merrimack in the past is there's been some groups that have been allowed to use it that are now forbidden because they trashed it or they didn't pay their fee. And I was wondering, would this amendment allow those groups to be, that the municipality would be forced to having to allow them to use the facilities, even if they have past practice of misusing them?
I would say no. I would say that would be a reason to say, wait a minute, although you say you're using this for a lawful purpose, your track record is that you have, you've trashed the last 3 times you were here or whatever, you've trashed the facility, or you've trashed other facilities or whatever, and that's a reason for you not to be allowed to use it. Representative Smith.
Thank you, Mr. Chair. I'm always leery about the legislature passing a bill that has to do with solving one problem in one town. Maybe that's small-minded of me, and I'm willing to consider an alternative. But I wonder if anyone is aware of any problem similar to what our distinguished colleague has experienced in other towns. And when we asked him a little bit about this, with that wonderful smile he has, he said, well, I'm a legislator, so I figured I'd just get a legislative solution instead of trying to find another solution. It's like when you go to a surgeon, the surgeon's solution is surgery. And I wonder if instead, if in this one case that's been brought to us, he had gone back and said, let's revisit this, or if he had chosen to go to court or do something else, if the problem might have been resolved, and if therefore we would be creating state law where there was no need to do that.
Yes, Representative Kutak.
So I am aware of some other towns that have stopped, for example, the LGBTQ community from holding events because they didn't want pride festivals because they questioned the appropriateness of having drag queens in the schools. I want to state that this would be like after school hours or in the summer. I know my town did allow the event to go on, but there have been several other towns that have rejected this. So I do think there are other examples besides just the example that the sponsor had introduced, because I have heard of the Pride Festival thing being denied in several towns.
Oh, yes, Representative Tripp.
Thank you, Mr. Chair. I agree with Representative Smith. During the the hearing, I basically said the same thing that she mentioned now. I think this is a point solution to a problem in one town that is going to be applied statewide. You know, that often doesn't end well, since most towns aren't like the town that this person lives in, and you know, it just creates more problems. So I'm in favor of ITL in the bill.
Representative Manis, did you have your hand up? Does anybody else have anything else they want to say? All right. So are we ready for, this is on the amendment. Are we ready for a vote on the amendment? And my sense is we should not do this by voice vote, but by a show of hands. And then, depending on what that is, we'll go to the main motion.
Because we have people in the room who have never experienced this, would it be appropriate for me to point out that it is possible to vote for the amendment and then against the underlying motion? So that, you know, it's not a question of in for a dime, in for a dollar. If you think that you don't really like the bill, but the amendment would be better than not. So I just want to make sure people know that.
Sure. No. That's a very good point. I'm glad you raised. Yes, Representative Manis.
Is it possible to make a verbal amendment to your amendment?
No. I'm sure you know, in many times, both the last 2 years and this year, I thought that would be a great idea, but it has to be.
Well, it is possible. We don't have to, the way you very appropriately set up the calendar, it says for those bills we haven't acted on today, we can act on them on Wednesday. So we don't need any other permission. And if in fact you want to delay the vote and submit and have another amendment prepared by OLS for us to vote on Wednesday, that would be possible.
So could I just ask you then, in light of that comment by Representative Smith, could you tell us, Representative Manos, what you're thinking your
Yes.
motion would say?
I don't know
Or your amendment would say?
Yes, I don't know the exact language, but its intent at least would be to exclude commercial speech so that we don't have libraries forced into allowing people to sell widgets.
Snake oil or Amway.
Right. Okay. Sure. Yes, Representative Stapleton.
Thank you, Mr. Chair. I'm having a pause, even on the basis of the subject matter to be addressed. There's some awful stuff happening out there, and probably will continue to be so, that's outrageous. Does this prohibit the municipality from putting the brakes on a distasteful, obscene, extremely offensive, disturbing subject matter displays and so forth in the public event?
This is my view of this. As I said before, I think if it's obscene, or it's, you know, a call to imminent violence or something like that, I think clearly that would be unlawful under existing law. When you say extremely distasteful, that's the thing that sort of troubles me, because I think that gets to the Skokie example. I think probably all of us would say that the Nazis marching through Skokie was extremely distasteful. I would certainly say that. But I tend to say, that they have the right to do that. And my concern, and I think really this is really Representative McGuire's concern that from which this emanates, is that there seems to be a sense in many officials at both the local level and the state level, and maybe even at the national level, that we can say that certain speech is just off limits, and the public doesn't have to listen to it. And even the Nazis in Skokie, as much as I find that really, really distasteful, I think that our First Amendment is designed to protect that kind of thing, and I think that's the basis of the bill. Yes, Representative Greason.
Thank you, Mr. Chair, and I think the amendment that may be suggested by Representative Manos would be to insert the word non-commercial between the words lawful and purpose on line 8.
Yeah, that may well be.
I would count on OLS to provide me with the language.
So, you know what, can I just, in the interest of sort of, for lack of a better term, not wasting everybody's time, could I just kind of get a general sense of, is that something that would make a difference in the final vote of of people who have expressed concern about the legislation? Because if it wouldn't, then it's sort of a waste of your time.
That's a fair question. So do you want to, are you asking to vote?
No, I'm not. No, I'm just trying to get us. I'm just. Yeah, could we get us? No, let's.
Hypothetically speaking,
Yeah.
with the proposed amendment as suggested by Representative Manos, how would you vote by show of hands at this point in time, please?
So you're talking about on the amendment or then on the final bill?
Right. In other words, let's suppose that Representative Manos, that we had before us Representative Manos' amendment that said, as Representative Greason suggested, that so that the language of the amendment was, no municipality shall discriminate against any individual or group in the use of municipal facilities for a lawful non-commercial purpose. So let's suppose that it said that, but everything else in the amendment was the same. Could we just sort of have a straw vote on whether people would be in favor of the bill, of the amendment with that language added? So I can have, if you would be in favor of it, could you raise your hand? If you would be opposed to it, well, so first of all, people would be in favor of it with that language. All right. So what are we on? 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. Okay. And the people that would be opposed to it, even if it contained that language.
No, we're talking about the amendment.
I mean, the amendment, right? The amendment. People that would be opposed to the amendment, even if it contained that language. One, two. Even if it contained non-commercial. 1, 2. Okay. All right. Okay. Well, then
It wouldn't be an
But the next
exercise.
question-
it wouldn't be an
Chair?
exercise in futility.
No, but then your next question
is-
that you have to think about is,
what-
if that amendment were to pass,
Right.
would you vote for the underlying bill?
Bill. Right. Now that's a good question. So maybe we should have a straw vote on that. So let's assume that we had the non-commercial language added, that amendment passed, which it sounds like it might, and now we're back. Now we're considering ought to pass the bill. Would you vote to OTPA the bill with the amendment, with the Manos amendment?
Mr. Chair, I would want to hear the discussion. After the amendment is presented, I would honestly want to hear the discussion before I reached a conclusion on the underlying bill.
Okay, all right. So, I'm still gonna add, I guess I would still just ask for a straw vote. I'm not gonna bind anybody if you change your mind. But I guess what I'm saying is, if everybody would say that they're gonna vote against it, even with that, then is there really any point in having that amendment? So can I just ask if you would vote, let's assume that the amendment was proposed with the accepting, removing commercial speech from the language, and that amendment passed, and now the question was, will you vote for the bill as amended with the non-commercial exception in there? How many would vote for the bill? So we have 1, 2, 3, 4. All right, it appears that bill will not, it appears that we would not have sufficient votes. So in the interest of not having you,
Would you like to amend your motion? Amend your motion.
amend.
Amend them.
Well, you know what? I guess I understand where this is going, but I guess I'm gonna stick with, even though I may be on the losing side, I'm gonna call for a vote on the amendment, and that, yes, Representative Staples.
Well, I'm going to throw another one in here, and I hate to do this, but
Well, that's okay.
I don't have a problem with the non-commercial aspect of the ad addition, but I'm reading this over, lawful purpose on the basis of, and I'm thinking, should that be lawful purpose solely on the basis of the subject matter to be addressed? There may be other considerations of safety, numbers, management resources, conditions of the venue, and putting the word solely in there does give us a little bit of latitude, so that it's not the most prominent aspect of consideration.
All right. Anybody else have any comments? Yes, Representative DiLorenzo.
Thank you, Mr. Chair. I didn't get a chance to weigh in, but I am not opposed to allowing public facilities to be used commercially. And I feel that way because there are some towns that might have a town hall or a town auditorium that's available for functions, social functions like weddings or, birthday parties or whatever. And it's a chance for the town to make some money, some extra income. So I think we have to consider that.
No, that's a valid point. So I appreciate your comments, Representative Stapleton. I have a sense that even with that language, that the amendment would not pass, and so rather than sort of having people go to the trouble of proposing amendments and writing amendments that would just prolong things, I guess I'm gonna. What's that? Sure. So if we added the solely if we added the solely language that Representative Stapleton has proposed and the non-commercial language that Representative Manos has proposed, and if that amendment passed, and now we were voting on the underlying bill as amended, can I ask for a show of hands how many people would vote? Whoop, all right, sorry.
So if it says the commercial part in there, does it mean that they could still accept commercial if they wanted to? Because like our town, for example, does do weddings and stuff, as Representative DiLorenzo mentioned.
I would say yes. It would just say they couldn't say that they don't have to, but they could. Yes, that's what I would say. Representative Smith.
I think we are all getting tired.
I think we are.
Not that I don't love being with you all. But do you think that the possibility that we're having so much trouble with this amendment is because this is really a local issue that should be settled locally, allowing for the differences from one jurisdiction to another? We're niggling at little piece here and little piece there, and I'm not sure we have to. I think we might just say this, we understand the problem, we respect the concern, and we believe that it is a decision that should be resolved locally, not that we are a local control state. We know we are not a local control state, but nonetheless, there are differences from community to community. And I'm reminded of something that we all tend to forget. It's not our job to take a bill that doesn't quite measure up and try to find a way to have it measure up. It is our place to take a good bill that does something that's clearly within our purview and try to, try to improve it. I am very fond of the sponsor. The sponsor and I are co-sponsors on some bills. So this is not anything about that. It's just that I think he's in the wrong pew.
Other other comments? Yeah, Representative Alexander.
Thank you, Mr. Chair. I don't see an amendment that will get a majority of the committee to vote ought to pass.
Right.
Or ought to pass as as amended. So I would suggest that we just ITL the bill.
Right. Yeah. So, I guess what I would like to say, I mean, believe me, I sort of understand where this is going. I don't mean to suggest that I don't, but I guess I do, I have great respect for Representative Smith, but I do, for the reasons I've said before, I do feel that this is a significant problem, not only in one town, but, generally. So I would like to have a vote on the amendment. And I understand that I may come up on the short end of that, but that's okay. Then we will go to, if the amendment doesn't pass, we will go to, another motion. So, yes.
Mr. Chair, may I ask for roll call on the amendment since it appears that it's going to be
Sure.
a split?
No,
Thank you.
that's fine. I have no problem with that.
Thank you.
All right, so so I'm going to call for a vote on amendment 120H to House Bill 256, and I would ask the clerk to call the roll, please.
Can I just
By-
clarify? This is just to amend the
the
bill,
amendment.
then we'll vote on.
Then
whether
we'll
to
vote
pass.
on the, right, yes.
Vice Chairman Wallace,
Yes.
Rep. Alexander,
Yes.
Rep. Andrews,
Yes.
Rep. Testerman, Rep. Stapleton,
No.
Rep. Tripp,
No.
Rep. Greason,
Yes.
Clerk, yes. Rep. Seidel,
Yes.
Rep. Smith,
Yes.
Rep. Horrigan,
No.
Rep. DiLorenzo,
Yes.
Rep. Schultz,
Yes.
Rep. Rung,
No.
Rep. Macbeth,
Yes.
Rep. Devine,
Yes.
Rep. Lanza,
Yes.
Rep. Manos,
No.
Rep. Turer,
Yes.
You didn't call me.
Chairman Lynn.
Yes.
Motion passes 15-5.
So now we're on to the underlying bill, and the motion is ought to pass as we just amended it. And so I would ask the clerk to call the roll on the OTPA.
Mr.
Vice
Chair,
Chair-
point of order. Was that motion made and seconded?
Oh,
OTPA?
I'm sorry, I make the motion to,
Yes.
good point, yes.
Yes, it was. It was already, you
Alright.
already motioned OTP and you moved the amendment.
Okay.
So
All right,
yes, it was.
1 second, all right. So I'm gonna ask you to call the roll on OTPA.
Vice Chairman Wallace,
Yes.
Rep. Alexander,
Yes.
Rep. Andrews,
No.
Rep. Testerman, Rep. Stapleton,
Yes.
Rep. Tripp,
No.
Rep. Greason,
No.
Clerk, yes. Rep. Seidel,
Yes.
Rep. Smith,
No.
Rep. Horrigan,
No.
Rep. DiLorenzo,
No.
Rep. Schultz,
No.
Rep. Rung,
No.
Rep. Macbeth,
No.
Rep. Devine,
No.
Rep. Lanza,
No.
Rep. Manos,
No.
Rep. Turer.
No.
Motion fails
Wait,
six.
You gotta call it.
Oh, sorry. Sorry, Chairman Lynn.
Yes,
Motion fails 7-13.
13-7. All right, 13-7 fails. All right. So now, do we have another motion? Yes, Representative Smith.
Mr. Chair, I move ITL.
All right, is there a second?
I'll second it.
I'm sorry, who second? Representative Tripp seconds. All right. All right, is there any further discussion? If anybody wants to say anything they haven't said before, please do. All right, are you ready for the, Representative Tripp, did you have something you wanted to say?
This is a bad bill. I think what you're is I've said, this is a local problem. if we make this a statewide issue, somebody's going to take it to court and they're going to define what is allowed and what's not allowed. And that's a problem, because what may be suitable in, say, Nashua may not be suitable in Concord, you know. And I don't think that the townspeople are going to be interested in living the life of other people just because they got to the courts first. So that's why I'm opposed to the bill.
Other comments? All right, oh, yes, Representative Stapleton.
Well, if this had happened to me, even if I'm a legislator, my first reaction would have been to go to local authority for a plea to waive or to make an argument. Failing that, take it to an attorney and bring it to court. Existing law and procedure that we have already on the books would be my first avenue, instead of coming in here and trying to make a law.
No, I understand your point. I think that was Representative Turner's point also, but I understand that. All right, so are we ready for the vote on the ITL motion? All right, okay, so I'd ask the clerk to call the roll on ITL.
Vice Chairman Wallace,
No.
Rep. Alexander,
Yes.
Rep. Andrews,
Yes.
Rep. Testerman, Rep. Stapleton,
Yes.
Rep. Tripp,
Yes.
Rep. Greason,
Yes.
Clerk, no. Rep. Seidel,
No.
Rep. Smith,
Yes.
Rep. Horrigan,
Yes.
Rep. DiLorenzo,
Yes.
Rep. Schultz,
Yes.
Rep. Wrong,
Yes.
Rep. Macbeth,
Yes.
Rep. Devine,
Yes.
Rep. Lanza,
Yes.
Rep. Manos,
Yes.
Rep. Turer,
Yes.
Chairman Lynn.
No.
Motion passes 16-4.
ITL, all right.
Not on the consent.
Not on the consent. All right, so,
Smith.
I will
so-
do the majority report.
all right, Smith for majority report, okay.
Is there going to be a minority report?
I'll let you know by tomorrow.
So we got a TBD Smith and we got a TBD Lynn. Good for the ranking member, it's good for the chair. Excellent.
All right, I think we are done.
Mr. Chair, before
Yes.
you send us off for tea and crumpets, could you just review the issues that are still open from today? One of them is that you have to decide whether you're going to do
I'm going to, a minority report on the last HB 256.
right,
Yeah.
okay, and I am deciding whether we're doing
63.
63,
On 63, right?
and the clerk has, because she doesn't have enough to do,
Subcommittee before Wednesday.
Right, on
it's going to
House
try to
Bill
come up with an
169.
amendment.
on 169, right?
And then for House Bill 240, Rep. Macbeth is writing a minority report. I just wanted to note that just because that's the only one.
Who is writing? Who's
240.
doing a minority on 240?
240 is.
Okay. So,
Well,
I'm
why
gonna-
don't you just, why don't you
guys-
decide?
all right. So on 240, you'll let us know. You'll let Representative Smith know within 24 hours if you're going to write a minority report on 240. All right.
I think we did pretty well.
I think we did too.
Yes. And for those that are new, this is how we make sausage.
Which is why most of us don't eat sauce.
Or
I love sausage. And I like it.
hours. All right. All right.
Thank you. I'm going to
And
leave
the-
some Dove chocolate out and welcome anyone to have it.
Oh, great. All right. So is there anything else?
I'd like to thank the substitutes who
Oh, yes,
did yeoman service.
for sure. So is there anything else that we need to discuss? Seeing none, I think we're adjourned, and we'll see everybody on Wednesday at 9 a.m. Great, thank you.